Hi there, I've just started the webinar to allow people to join. So I'm going to give that a moment because I've got a lot of people who want to join today, which is fantastic. Hello, everyone, and welcome to our January webinar. If I can still say a Happy New Year, even though we are practically at the end of the first month of 2024, which is incredibly scary in itself. But I hope you've all been rested and are raring to go for what is going to be a busy 2024. Also, what has been fantastic is that we have had a lot of new people join for our January webinar who maybe don't know what the programme is all about. So for those who don't know me, I'm Emma O'Connor. I'm a legal director within the employment team, and I head up our bespoke HR and manager training academy. And the purpose of our webinars is that every month we bring you a topic, something of interest to HR professionals and also to our business leader community as well. So lots of opportunities to get involved. What I will say, though, is that our webinars are an overview. They are really a kind of an HR heads up, so what things to think about. They don't give specific legal advice and are certainly no substitute for taking specific legal advice, but I'll be telling you about how you can get involved and opportunities that might be available to help you as we navigate our way through 2024. Lots of ways to sign up for our updates, subscribe to our YouTube channel, and also get involved in LinkedIn as well. So for those of you who don't know about Boyes Turner, we are a full service commercial law firm based in the Thames Valley, but look after clients all over the UK, Europe, and further afield as well. In the employment team in particular, we look after clients, their HR day-to-day advice and support, litigation, and we also look after clients in terms of training, as I've said, but also business immigration as well. So lots of help and assistance that we can offer. And I'll be telling you about how you can get involved or get in contact should you need any advice. So as I've said, today is going to be a bit of an HR heads up in terms of what legislation changes we can expect this year. So I will be giving you a bit of a whistle-stop tour, focusing on changes in January, so what changes we have already had. April is going to be a key month where we're going to see lots of changes. And then I'll also be talking about some of the changes we can expect to see as we move forward and move to the latter part of 2024. I know a lot of you have been reading lots of stuff about the changes, and I appreciate that there is a lot of content, that's going on. So what I want to do is really just kind of pick up on those key details, those key areas where HR might want to think about and prioritise, because there's obviously some things that you will want to look at for your own businesses, and we're all at different stages in terms of our HR and people management journey. So for some of you, it might be looking at policies. For some of you, it might be drafting policies because you don't have one, and certainly looking at things around how we can kind of really up that training and awareness for our managers and for our HR teams. So let's kick off with looking at what changes we saw in January. So I should also say as well that I am live today, and this will be recorded and will be on our YouTube channel, and I will be sending out the link. If you want to ask questions, that's fine. I will do my best to have a look at those as we go along. If anything is specific or we do sort of run out of time, then again, I will deal with those after the webinar where I can. So let's have a look at January and what changes we saw from the 1st of January. Now, a lot of the changes that we saw are things that either we already know about, we're already doing, but the aim of the January changes was really to bring into domestic law a lot of things and a lot of policies and processes and rules that we were following because of European case law, and because we've left the European Union now, and we've lost that sort of supremacy of European courts. It's really bringing into UK law the rights that individuals had so that they are not lost. And also, really, when we talk about the changes, and one of those key changes has been around holiday and how we look at holiday, how we calculate holiday pay, particularly rules around carryover. But I think it's worth just reminding ourselves in terms of what holiday is and what the purpose of it is. So the holiday rules in the UK are set out in the working time regulations. And the purpose of holiday is as a health and safety obligation. It's something that individuals should be taking for their health, safety, and obviously their well-being. Also, we have to think about holiday as not just being an employee right. The rights to take holiday have a wider remit, so they apply the rights to holiday and holiday pay as set out under the working time regulations, apply not just to employees, but to workers as well. So we've got that wider category of who may be impacted. And also just to say that the working time regulations is the basic minimum. So it sets out that kind of baseline requirement in terms of holiday. So the amount of holiday that individuals are able to take, that minimum that employers must not go below. They can obviously give more holiday under contracts of employment, and many of you will be doing that. So they are that baseline obligation, those baseline rules. So as you'll probably be aware, there was lots of consultation around the proposed changes to holiday. And one of the proposals was that we have, under the working time regulations, just one single set of holiday. So at the moment, we have two types of holiday. So we have that basic holiday, that basic EU holiday entitlement of 20 days. And then in the UK, we have an additional 1.6 days holiday. And there was consultation about bringing that together so there would just be a single basic minimum holiday. But actually, what has been decided is that we're not going to do that. So we're going to retain the distinction, and you'll see when I talk about some of the changes why that distinction is so important. So we're going to retain that basic 4 weeks holiday plus the additional holiday. Again, many of you may be offering more holiday in your contracts of employment, but that's the kind of the baseline. So we're going to keep that distinction. Now, what we did see from the 1st of January is that specific rules were brought in with regards to carryovers. So when can holiday be carried over? Now, again, this probably is no different to what you were already doing, because a lot of the rules relating to holiday, particularly relating to those who are on long-term sickness absence and what happens to their holiday during their period of absence. So in particular, those rules were already set out in European case law. So again, it's about bringing those rights, making sure that those worker rights have not been lost. So what are the specific rules now when it comes to holiday? Well, now there is a specific right for workers to be able to carry over holiday where they've been unable to take holiday due to statutory family leave, so on maternity leave, etc., due to sickness absence, so long-term sickness absence, where the employer has not given the worker an opportunity to be able to take that holiday during the holiday year, or has failed to tell the individual and warn them that if they don't take holiday, it's going to be lost. And also there's going to be a right now to carry over where there has been some confusion as to the status of the individual who is working for you. Now, what I would recommend that you do is that you go and look out for the new government guidance that has been published to support the changes, so to support the change to carry over and the other changes that I'm going to talk about, because it's really good. And actually it does give some really good worked examples and an explanation as to, you know, the types of carryover rights and also the type of leave that can be carried over. And this is where we see the importance of the 4 weeks and the 1.6 weeks leave. So for example, in the case of long-term sickness absence, individuals there would be able to carry over the basic 20 days or 4 weeks holiday, and that can be carried over for 18 months after the end of the holiday year. So again, have a look at what types of holiday can be carried over and in what circumstances. And also, I think particularly with regards to holiday for where you've got employees who are going off on statutory family leave, again, we might need to look at how we're managing that holiday. And I know for most of you, what tends to happen is that you allow individuals to simply tag on their accrued holiday to the end of their maternity or adoptive leave, whatever the case may be. But I think it's really kind of focusing on having those conversations with individuals about their holiday, having those conversations early, particularly before individuals go off on family leave, and discussing how you're actually going to make that leave work in practice. And remembering, of course, that you can't pay in lieu of untaken holiday unless we're in a termination situation. So I think some practical help there in terms of what holiday can be carried over in those specific situations. So I think some helpful tips there. Other changes that we've seen from January, some changes to the need to keep records of hours worked. So there's not going to be that obligation to keep daily records. However, there is going to be a need to make sure that you keep the records that you need to be able to show that you're complying with the working time regulations. So I think it's a little bit kind of, it looks really good, but actually in practice, I think a lot of you will want to keep records, particularly for irregular workers, so casual staff, etc., to be able to show exactly what somebody has worked, particularly if there's any disputes there around pay, but also making sure, as I've said, you need to keep the records that are specific to your particular sector, your particular business, to show that you're complying with the working time regulations. So sounds good, but it might not really make much difference in practice. One thing that we are going to have to think about is our lockdown holiday. So as many of you may remember, there were rules that were brought in back in 2020, which dealt with the situation of individuals not being able to take their holiday because of lockdowns. And what was going to be allowed is that individuals would have a period of time with which to be able to take that accrued lockdown-related leave. Those rules are going to be repealed as of the end of March of this year. So we need to be auditing holiday, who has carried over leave, lockdown related carried over leave, and remembering now that we need to tell individuals that if they do have that leave, it's basically use it or lose it before the end of March. So again, we might need to be thinking about, is it possible for individuals to take that leave? You know, we haven't got a great deal of time to be able to take any carried over leave between March, but we need to be warning them that if they don't take that leave, it's not going to be paid for. And obviously that right will be lost. So audit, audit, audit. Who's got what holiday, what's been carried over, what's been taken, what hasn't been taken. So need to be thinking about that. And again, communicate with staff as well. Give them the heads up that, you know, if they've got lockdown leave, it needs to be taken or it will be lost. Now, another reason why that distinction between the 4 weeks basic pay and the additional 1.6 weeks of leave, so that UK additional enhanced leave, why that's important and will continue to be important, particularly under these January changes, is what individuals are paid for their holiday. Now, I've been talking about holiday pay, writing about holiday pay, reading about holiday pay for more years than I care to think about, because it's been one of those hot topics about what is included within an individual's holiday pay. Now, if we think back to what the purpose of holiday is, again, it's that health and safety, that well-being, why people need to take their holiday. It's really important for them to take their holiday, but also making sure that individuals aren't penalised financially for taking holiday. And what we saw was a number of cases that went before the European courts, which said, look, I'm actually being penalised financially because I'm only being paid my basic salary for when I take holiday, and I'm losing money because if I was at work, I would be earning commission and other sort of payments. So again, it's about making sure that those European cases, those rights, those worker rights are now enshrined within UK law. And one of those is about how we calculate holiday pay and what we have to include within that calculation. So again, many of you are already doing this. You're already including that normal remuneration. So you're not just looking at basic pay within your holiday pay calculation. But for some of you, you might need to go back and think about what are we actually paying. Now, there are separate rules in terms of how we look at pay for our irregular and part-year workers. But where you've got individuals who have that normal, normal working days, that they may earn overtime, they may earn commission. So again, you've got that ability to be able to break up the holiday. So certainly for our basic holiday, for our 4 weeks, we really should be paying that at normal remuneration. So looking at those payments which are intrinsically linked to the work that the individual does for you, remembering it's not just employees, it's workers as well. So what payments in addition to somebody get for doing the work that they do for you? So looking at that. And there is, for that additional holiday there, that ability to pay for basic pay only. However, many of you I know are looking at basically the whole of the holiday entitlement, so you're not breaking it down. We need to think about what is included within normal remuneration, and there is some helpful guidance as set out in the government guidance there. So really, what payments are linked? What is it that's part of the job? Intrinsically linked is the phrase. So again, take advice. Do we need to be looking at what payments we are including? We need to be thinking about our reference period. So, what is being paid to individuals directly before they get paid. What's the reference period we need to be thinking about there? Again, some issues there with regards to bonuses. That's always been a sort of a bone of contention when it comes to holiday pay. So again, we need to be thinking about what are we paying our individuals and making sure that individuals are not being penalised financially because they take holiday. So have a look at that. Also take advice and make sure that you are paying correctly in terms of what is and what is not holiday pay. Now, I know for many of you, there was a real kind of scratchy head moment, myself included, when we had the Harper Trust and Brazil case, which really kind of sort of, completely threw away what we knew and what we thought we knew about how we calculate holiday and holiday accrual for those individuals that have irregular working hours or those individuals that work part year. And we ended up in a situation where part-year workers seem to have more holiday than those individuals who work part-time. So the government responded quite quickly on this. Consultation came out. Many of you will have responded to that consultation. And what we see now, so the change that has been made, but again, it is only where your holiday year is on or after the 1st of April 2024. So for some of you, if your holiday is January to December, you're going to have to wait till the next holiday year before these changes will actually make a difference. So again, look at your holiday years. When can we start applying this change? But essentially, we are forgetting that Harper and Brazil ever happened, and we're going back to what we had under ACAS guidance before Brazil, and also what we were used to. So we will be going back to that original accrual method of looking at holiday pay on the basis of 12.07% of a worker's normal rate of pay, and using that to calculate holiday pay. Remembering, we're just talking about our irregular workers, and we're just talking about our part-year workers when we're looking at this change, and that's really important to note. We're also, again, on or after 1st of April, looking at that ability now to be able to roll up that holiday pay, again, part-year, irregular workers only. But there is going to be that ability to be able to break that down. So this is your pay, and this is your holiday pay. If you are going to be using rolled up holiday pay, again, please remember that that needs to be broken down on the pay slip. So there's no confusion in terms of what you're being paid to do the job and what any accrued holiday pay is as well. So again, please make sure that you've got those practices and those processes sorted by the 1st of April, if that's your holiday year. So actually a really sensible way to be able to approach holiday and holiday pay for those individuals who don't have, regular hours and regular pay. But for some of you who do have that holiday pay later, holiday year later, so next year's is our start of the holiday year, you may have to wait. So you are currently you are within Harper and Brazil for a few months to come. So again, just bear that in mind. So what do we need to be thinking about? Well, some of the things that I've already touched on. We need to be looking not just at our holiday policies. So again, looking at what we say, particularly with regards to carryover. Do we have that distinction between those individuals who are on family leave, who are on sick leave? What are we saying about carryover there? But it's not just what we have in our policies or our contracts, but obviously making sure that we're actually doing the right thing in practice. So what happens in practice when somebody is on family leave? Are we having those conversations with them? Are we making sure that they've got that ability to be able to carry over holiday? So again, policy is great. What are we doing in practice? And that really is going to involve making sure that your HR teams and your managers are aware of what the changes are and what that means. Also thinking about, getting your managers aware that somebody might be off for a bit longer than they think, particularly if they're going to add their holiday on to the end of their maternity leave or their adoption leave. So thinking about how that's going to work in practical terms, and as well remembering about, looking at what somebody is paid during the actual family leave, as well as then what they're paid for their holiday is going to be different. So we need to think about budgeting and factoring that into our costs as well. Look at your calculation methods. As I said, a lot of you will be completely all over this because we should have been. This is not anything that is necessarily new. But again, it's making us kind of revisit, are we making sure that individuals are being paid their correct pay for the holiday that they're taking? And again, thinking about whether you want to have that distinction between the 4 weeks and obviously the 1.6 weeks, or actually in practice, is that just going to be just too horrendous? to be able to manage. So thinking about that. Auditing holiday pay. Auditing holiday, we need to be doing this anyway. We need to be making sure that employees and workers are taking their holiday at regular intervals throughout the holiday year. So not just auditing, has anybody got any lockdown leave, but also making sure that individuals are not getting to December, if that's your holiday year, and haven't taken any holiday. So again, being on top of when people are taking their leave, because it's good for them. It's good for their well-being, good for their health and safety. And again, thinking about that distinction that I've just talked about in terms of for our part-year workers and our irregular workers, check when your holiday year is, and making sure that you're ready. If you do have an April holiday year, making sure that you're ready to put in place those changes with regards to calculating holiday pay for our part-year irregular workers, but also making sure that you've got things in place. If you are going to be doing the roll-up, again, part-year irregular workers, making sure that you've got the processes in place to make sure that that is set out clearly on pay slips. So there is going to be some work to do around holiday. Many of you, I hope, were already doing this, but it's never a bad idea just to go back and check, are we really complying with what we need to be, but also making sure that what you do in practice and what you say you're going to do is actually what you are doing. We saw some other changes. Again, this is about bringing that European case law, so making sure that workers' rights that UK workers had before the 31st of December are still in place, still making sure that we've got those protections for our workers and our employees in relation to the Equality Act. So what we saw here is we've seen some changes that have been brought in. Again, it's nothing new. We should have been doing this anyway, but I think it's always good just to remind ourselves as to what those protections are. So again, we've got some protections there, some direct protections, direct discrimination protections for our women who are pregnant, on maternity leave, who are breastfeeding. We have got now the bringing into UK law following a European case, this protection for indirect associative discrimination. So we have indirect discrimination now, so where an individual themselves has a protected characteristic or perceived protected characteristic. This is protection for an individual who they themselves does not have the protected characteristic or the perceived protective characteristic, but somebody associated with them, someone closely associated with them does. So again, it's about making sure that that European protection is brought into UK domestic law. The next change, again, I think this is one to sort of flag, is around discriminatory statements in the recruitment process. So this is one where stopping or seeking to prevent statements being made by employers around statements such as, we are never going to employ somebody who has X protected characteristic. So again, making sure that those statements are not said, and again, protection where those statements are said. I think the change around the definition of disability discrimination is going to be an interesting one. So as we know, the definition in the Equality Act regarding disability discrimination is looking at that physical or that mental impairment which is substantial. So looking at those impairments which will last 12 months or periods of 12 months, and where they have an impact on someone's ability to carry out normal day-to-day activities. So mobility, concentration, data analysis. And what we have seen and what we've seen from January is this extension when we're looking at the definition of normal day-to-day activities. What we're going to see is an enhancement there. So looking at whether an individual is able to participate fully and effectively in working life on an equal basis with other workers. So again, that extension there as to, ability to fully participate. And again, that's going to encourage employers to look at their working practices. Are they really inclusive? Really focusing on and supporting those individuals who are disabled or who become disabled during their working time with you. So again, a focus there on disability discrimination. And another change that we saw in January is looking at equal pay and that ability for individuals who are seeking to argue that their pay is not equal with men who do like work or work rated as equivalent. So looking at who they can compare themselves to, and again, broadening the scope in terms of the comparator for equal pay. So some changes there. Again, with all changes to discrimination law, I can't emphasize enough the importance of training, raising awareness, really being able to demonstrate to not just your workforce, but also to an employment tribunal that you as an organisation take equal opportunities seriously, that you're not just saying you're going to do this stuff, that actually in practice, this is what we do. This is the awareness that we have. These are the policies that we have in place, but it's not just a policy on our intranet. We really do eat, sleep, breathe this stuff. And training your managers, raising their awareness, making them think about, how inclusive are they? What are the risks involved if you do have a claim for discrimination or harassment? And that's going to become even more important when I come to talk about changes with regards to sexual harassment and what's changing there. January again was another busy month. We saw changes, didn't we, to national insurance contributions. So again, making sure that we've got those changes embedded, payroll systems, etc. Another change, and one where I think this awareness and training is going to be key, is around right to work checks. Right to work checks are really, really important. So again, making sure that we've got our processes in place, making sure that we're auditing our workforces. So again, training for managers, training for HR teams. What are the right to work check processes? And what does that look like for your business? And are you doing them? So again, the fines for right to work checks have gone up, and they went up from the 22nd of January 2024. So again, some changes there to immigration that we need to be aware of. So January was a busy month. Our next busy month is going to be April. So really we want to start thinking about these now, certainly, but it's going to become more pressing as we move towards April, in particular 6th of April. So what have we got? Well, we've got some changes to the national living and national minimum wage, as we have every year. A couple of points to note about the changes this year is that the age that a worker will be entitled to receive their national living wage is changing. It's going down to 21. So the national living wage, which is going up to £11.44 an hour, is going to be applicable for those who are age 21 and over. The national minimum wage, £8.60, and then apprenticeship rate is going up to £6.40. So again, making sure that we've got those changes in place and really noting that new age, 21. 21 is the new 23. Also, changes again to those statutory rates of pay, so statutory maternity, paternity, bereavement leave, etc., and that's going up from the 22nd of April to £184.03 a week, and statutory sick pay is increasing from the 6th of April to £116.75. So again, let's make sure that we're getting ready for those changes and we're all up to speed with what those changes are going to mean. A big change, and one that I think we're going to have to think about, particularly in terms of our redundancy processes and our timings and our notification procedures, is around the protection during redundancy for those individuals who are at risk. And the protection that currently exists is going to be extended from April of this year. So let's kind of roll back a minute. So the protection currently is afforded to those individuals who are on maternity leave, adoption leave, and shared parental leave. And the protection is that if your role is placed at risk of redundancy and you fall within one of those statutory leave periods, then you have the ability to be notified about suitable alternative work before others within the at-risk pool. So that's the current state of play with regards to that protection. However, after consultation, that protection, so that right to be notified about other jobs, is being extended. And one of the reasons for that is often employers would simply wait until an individual returned from maternity, adoption, shared parental leave, and then they would start a redundancy process. But now that protection is being extended, and it's being extended to individuals who are pregnant. So where individuals notify their employer of their pregnancy on or after the 6th of April 2024. So that right to be notified of suitable alternative jobs, again, is going to be extended to those who are placed at risk of redundancy whilst they are pregnant. There are going to be special rules for those who may miscarriage or have a stillbirth during that period of time. So special rules there, but protection there for individuals once they notify their employer of their pregnancy. Then we are going to see the protection extended. So not just during maternity, adoption, shared parental leave. At the moment, that notification right stops when an individual returns to work. That's going to be extended for up to 6 months after the date somebody returns. So, for example, if you think about an individual who takes then a year as maternity leave, potentially that protection will be for 18 months. So again, some time issues there, timing issues. One thing to say is that there was some sort of confusion as to individuals who took shared parental leave. Would this right, this protection, this added protection once somebody returns from shared parental leave, would there be any stipulation in terms of how long an individual has to be on shared parental leave for? Yes, that's been ironed out. So we're looking at individuals who are on shared parental leave for a minimum period of 6 weeks consecutive leave. And also, if an individual takes maternity and adoption leave and shared parental leave, you don't benefit from 2 lots of 6 months worth of protection. If you take maternity and adoption leave, you get the protection under that leave. If you just take shared parental leave, you get the protection under that leave. So what are we going to be thinking about? Well, it's going to have an impact on our redundancy planning. And actually next month, the February's webinar, I'm going to be looking at redundancy and some of the issues around that. So we're going to have to be thinking about timing. We're going to have to be thinking about our processes and our procedures. Also, not forgetting individuals who are on family leave. It still happens that a woman goes off on maternity leave, has 12 months off, and then when they come back from maternity leave, they find that somebody's been promoted above them and they had no idea about what the job was going to be. So again, remembering to keep those who are on family leave and on sick leave, in the loop about suitable alternative roles. And again, we're talking about those suitable roles. We're not talking about creating roles. So I think we are going to have to be thinking about when those rules apply, what those rules will mean. So again, let's start thinking about that now, particularly around April. So some rules there that we're going to have to be thinking about, particularly when we've got individuals on those maternity leaves, adoption leaves, etc., and how long that leave and that protection extends for. So look out for our February webinar when I'll be talking about that in some more detail around redundancies. I think another major change, the kind of flexible working revolution, big changes here to the way in which flexible working requests, and remember, it's still a right to request flexible working. We don't have an absolute right to flexible working, but we've got some big changes here which are going to impact the way that we manage flexible working requests. They are going to impact upon who can make flexible working requests, and also how internally we manage those processes. So key issues that we need to be thinking about are flexible working is going to become a day one right from April. So we're not going to have that 26 weeks of continuous service, which we currently have. Individuals are going to be able to make 2 requests, statutory flexible working requests per year. At the moment, they can just make 1. And the length of time that an individual has to be able to, the amount of time the employer has to be able to manage that flexible working request is going to be reduced from 3 months to 2 months. And that will include giving the individual a right of appeal if you choose to follow the ACAS best practice, which is to give an individual a right of appeal. And certainly in the flexible working policies that I draft and the advice I give, I do advise employers to give that right of appeal, because it's just another opportunity for another individual within the business to be able to review the request if the original decision is no. And there will be a new ACAS code as well, helping employers manage those requests. I am going to be running on the 14th of March a virtual training course aimed at HR, aimed at managers, which will focus on how this is all going to work in practice, particularly around how we're going to make our processes work, considerations that we need to be thinking about when we get requests in, remembering it's universal. It's a universal day one right for employees. Also looking at those risk areas. So if we say no, how are we going to say no? What does that look like under the new process? Because there's going to be some changes around the consultation process. And also thinking about those statutory grounds. What are the statutory grounds? There's 8 statutory grounds, and how can we use those when we are saying no to a request, and what does that look like? So we're looking at some practical issues. So watch out for invites on that. It is going to be pay per attendee, but what I want to do is look at teams. So if you want to run the session for your team, so your HR teams or management teams, again, looking at kind of having an individual price for that. So again, get in touch if that's something you want to explore with me. But again, virtual course, opportunity to join, sign up to receive invites. Again, they'll be through the newsletter on socials as per usual. So again, chance there to do some real kind of deep dive in terms of what flexible working looks like. Another change is around paternity leave. Now, this one kind of sort of was mooted, and then it sort of came in quite quickly, actually. But it's really looking at how paternity leave works in practice and trying to make it more, make it work really for people's lives and how situations work. So moving away from this, you have to take a paternity leave in very prescriptive ways. So, you know, you have to take it either 1 week or 2 week. Now you can take it as 1 week, 2 weeks consecutively. What we're going to be looking at in April is this ability to be able to take paternity leave within the first year of birth or adoption. So again, not this prescriptive, and you've got to take it within 56 days of birth or adoption. So again, looking at making it work more effectively for the way people's lives work. Again, looking at shortening the period of time, making it easier for employees to be able to request or change their dates. So there is going to be some changes there to paternity leave from April. Also, there'll be some changes to paternity pay as well, because again, if people are taking different pay at different times, again, some work to be done around that in the legislation. So we are going to have to be looking at our paternity leave policies, as well as looking at our notification procedures as well. And again, making sure managers are aware of what the changes are going to be. But I think some sensible changes there just to make paternity leave work more effectively. New leave, carers leave, again, 5 days unpaid leave for those individuals who have caring responsibilities, so looking after an individual who has long-term care needs. It's a day one right. For employees, it is unpaid, but individuals are going to have a lot of flexibility in terms of how they request that leave. It can be on a half day, full day, a whole week. Cannot be treated less favourably because the individual has requested caring leave. This right is going to be on top of that right to be able to take emergency leave to deal with, emergency situations involving somebody's care, but this is going to be another right. But as I've said, new policies, processes, awareness that that right is unpaid as a statutory minimum employers may want to pay. Again, that's something that you might want to think about, an opportunity there. Neonatal leave as well, statutory neonatal leave, that's on ice at the moment. So again, I'll keep you posted if we need to be doing anything about that this year, but looks as if that one's on the back burner for now. Summer, early autumn, just having a little look ahead. What do we need to have on our HR radar? You work in hospitality, again, allocation of tips law, summer, early autumn, that's really going to be encouraging employers to have those policies. How are we going to be working out our tips, making sure they're fairly allocated, reducing the amount of time between the tip being paid by a customer and then it making its way into somebody's pay packet. Again, that period of time has got to be done within a month. So I know there's some work to do, particularly around those businesses that maybe keep a pot of tips in reserve for those, fallow months, so January, February, March. So again, there's going to have to be some work around that. It's looking at those tips that employers have control over. So not cash tips per se, but really those sort of service charges that are being placed onto people's bills. So again, get in touch. We're drafting policies for individual businesses now, if that's something that we can help with. TUPE, looking at some consultation changes for those transfers taking place on or after the 1st of July, and really looking at those smaller scale TUPE transfers where the employer does not have a standing employee representative body. So where you have employee representative bodies, trade unions, the rules currently around information consultation will still apply, but where employers don't have that standing body of employee representatives, where an employer has less than 50 employees, irrespective of the size of the transfer, or where the proposed transfer includes less than 10 individuals, again, irrespective of the size of the employer, then employers will be able to directly inform and consult with affected employees, so not having to go through that election process. So again, something to look out for as we move forward. Sexual harassment, as I mentioned, there's going to be some real need to get our managers trained in terms of what are we doing about awareness, not just for discrimination and harassment more generally, but specifically around sexual harassment and this introduction of the duty to act reasonably. So it's really putting that emphasis on employers to be proactive. What are you doing to proactively stop sexual harassment going on in your workplace? So moving it away from that reactive approach to being proactive. So again, what steps are we taking to basically prevent sexual harassment? So again, training, key here. What training are we doing for managers? That legal training around harassment, in particular sexual harassment, policies, you know, notifications. So how can people raise it? Employees knowing that when they do raise issues, it's going to be taken seriously by the employer. So some real practical steps that businesses can be taking now to make sure that you're ready for the changes in autumn. And if employers are found not to have acted reasonably, then there is going to be that compensation, penalising that is going to happen in the employment tribunal if a tribunal finds that the employer has not carried out its duty to act reasonably with regards to preventing sexual harassment in the workforce. So again, real opportunity there to get equality up there in the mindset of our managers and HR, making sure that we are training on what those obligations are and what the risks are as well. For our irregular workers, again, looking forward to autumn, that ability for them to be able to request regular working patterns. So more predictive working patterns. Again, it's only a right to request. Individuals will be able to make 2 requests per year, but they will need that 26 weeks of continuous service or periods that add up to that. And again, employers can say, no, we're not going to give you predictive hours when there's going to be some statutory grounds, similar to what we see with flexible working, and there's going to be an ACAS code of conduct as well. So something to look out for as we move forward into 2024. So lots to think about, lots to get on the front foot as well, I think, from an HR perspective, particularly around our policies, particularly around our processes. I think training as well is going to be a really key area, particularly on equality, particularly on the obligations under the Equality Act, sexual harassment obligations as well, there's preventative duties. And I think around, you know, right to work checks, business immigration, making sure that your managers know what the obligations are. So we've got time to prioritise, we've got time to really think about those areas that we need to be focusing on. When do you need to get advice? So we are helping businesses not only with their training, but looking at, you know, their policies, their processes, thinking about, if you are looking at redundancy, how that might look with those individuals who are on current family leave. So again, looking at how those new rules may impact on what decision making that we want to be taking. So there's lots of opportunities for HR to really, you know, make their voice heard, and we can help with that, as I've said, not just with giving advice and support, but also in the programs that we've got available. So again, as I mentioned, looking at the February webinar, when we're looking at redundancy, March, looking at virtual flexible working, so running a training course on that. You can join, it's open to anyone to join that. So again, look out for invites to that. March as well, I'll probably look at particularly the protection around, you know, maternity, paternity leave, and how those sort of changes affect, looking at those in a bit more detail, because I think there's some things there that we need to kind of look at, and again around sort of, you know, holiday carryover, etc. Just a couple of dates to flag to you. 26th of June is, I'm going to be running the HR Masterclass. So again, look out for invites for that specific course drafted for HR, what sorts of issues HR are going to be dealing with. And then in October, after the success of the Manager Masterclass in 2023, I'm going to be running that again, but also thinking about manager training as well. So looking at not just waiting for October, what training can we be doing now bespoke for our managers, and how can we get the managers engaged with the sorts of obligations and risk areas that they are going to need to know about. So again, some dates there. Look out as well for our podcasts on HR updates, but also those HR hot topics as well. So again, look at LinkedIn, sign up for our updates, subscribe to our YouTube channel. And again, if I can help at all, my email address is eoconnor@boysturner.com. So do get in touch with me if I can help as well. So thank you very much for joining me today, and I look forward to seeing you at future webinars, podcasts, and also at our training courses that we've got coming up. And as I said, do get in touch if I can help at all. But thank you very much for joining me today.